by and large, barring some very honorable exceptions, by and large, it's difficult to get a relief in cases involving civil liberties, free speech, etc. One has to go to the Supreme Court. That's a troubling point.
Welcome to the Bombay Bar Association Podcast. I'm Gaurav Joshi and I'll be a host on this episode. Today, we have with us former Chief Justice of the Madras and Delhi High Court and former Chairman of the Law Commission, Justice A.P. Shah. His record on the bench can be captured in 3 words: inclusive, insightful, and fearless. Justice Shah, you grew up in Solapur and initially practiced law there with your grandfather. What do you love the most about growing up in Solapur?
Solapur was predominantly a milk workers' town. It was relatively smaller. Now it has grown big. Being a border district, the population was multilingual. So Marathi, Kannada, Telugu, all languages were spoken there. There was a sizable Muslim community who spoke Hindi. There was a small Gujarati community who mostly speak Marathi at home, like my family. My father and grandfather were lawyers. There were many lawyers in our locality. Justice Damdar, his father and grandfather were lawyers. His father later became a judge of the Bombay High Court. Their family lived there. Justice Uday Lalit, former Chief Justice of India, his father, grandfather were all lawyers, and their family lived there. So there were lawyers, black coat, around me.
It's amazing the number of lawyers you grew up with or surrounded with. Your grandfather was the president of the Hindu Mahasabha. Your father was a freedom fighter and a follower of Mahatma Gandhi, and later a High Court judge. How was it to grow up around such personalities at home?
My father was the president of All India Hindu Mahasabha in 1940s. So Savarkar, Munje, all Hindu Mahasabha leaders visited his house. From my family, they were all followers of Gandhi. My mother was inspired by Gandhi, though she was from a Hindu Mahasabha family. So someone complained, she joined Rashtra Seva Dal. So someone complained to my grandfather, and she said, no, she's doing good work, so nothing to worry. My uncle, Vilas Shah, a brilliant lawyer, he was staunch Gandhian. He died many years back, but on his birth anniversary, someone remembered him and wrote that he was the last Gandhi. The first literature to which I was exposed through my maternal grandfather was all books of Savarkar, prose and poetry. So, on the other hand, there was this Gandhian influence.
What made you pursue law then?
I joined Government Law College at the insistence of my parents. Even then, I was not keen to join the legal profession. But I started attending cases in Bombay High Court. One case really stuck in my head. That was a trial. Acharya Atre, a famous journalist, orator, a very popular figure in Marathi. I had performed one of his plays in college. He died. He allegedly left behind a will, giving all his assets to a trust of Communist Party. His daughters challenged the bill. And this case came before Justice Solapur. This trial was before Solapur, who conducted it with great aplomb. Mr. J.C. Bhatt was appearing for the daughters, and Mr. A.B. Shah was on the other side for the trustees. So I watched the trial for almost 3 or 4 days. So Mr. J.C. Bhatt cross-examined the attesting witness, a senior party functionary. And I literally saw the witness melting in the witness box. And then I realized there was so much drama and excitement in the legal profession. Perhaps I believe that was a turning point, and it made kind of a change of heart, and I decided to join the profession.
It's clear that the best inspiration a young lawyer can have is to watch a trial.
Watch a trial,
live trial.
That's absolutely.
You get to see all aspects of the law and
Right,
particularly interesting aspects like cross-examination. Your approach to free speech, particularly your liberal approach, is notable in the Anand Patwardhan case.
Anand Patwardhan's documentary was named Ram Ke Naam, and it was about Mr. Advani's Rath Yatra. This documentary won the President's Medal. And the policy was that all documentaries winning President's Medal should be shown on the TV. But the government refused to telecast this particular documentary. I directed the government to telecast this documentary on TV. Not only that, but I said that it should be shown at prime time, because they might have shown it in some odd hours. Nobody would watch it. I truly believe in the free speech, not merely because it's a part of Article 19, but still I firmly believe that, and as Justice Venkatramaya said, most important fundamental right is right to speech.
Right to speak.
And all other rights follow from right to speech.
Absolutely, because free speech may be a part of Article 19, but if you read it down by saying that there are reasonable restrictions. So it depends upon your approach.
That's right,
to the concept of free speech and how you would want it. And I think that Anand Patwardhan judgment really made it very clear.
And,
the liberal
Gaurav,
views.
many other rights were derived by the Supreme Court, like right to information, is derived from
the
right to speech.
Once you joined the profession, were there any incidents which highly impressed you and had a lasting impact on your career as a lawyer and thereafter as a judge?
See, as I said, I started with my grandfather at Solapur. My father said that I should have some experience in the trial court. And that time I started taking cases to Bombay High Court, taking my own cases to Bombay High Court. It was my first or second case. It was before a bench presided over by Justice A.P. He was a fantastic judge. He had imposing personality, a razor-sharp mind. He would literally read vertically. And it was an election matter. My client, I think he was a panchayat member. He was convicted and sentenced for more than 2 years. So he was disqualified. The question was whether this could be done in an election petition or this has to be, power is vested in the district collector. So there were conflicting judgments. So I collected some authorities, some 7-8 authorities on this. And in those days, Gaurav, there were no Xerox copies. So I collected the books from the library.
No SEC online, nothing.
So I collected the books from critical library and they went to the court. And you had to instruct the court officer so that he could bring the books for the judges. So I sat there and the judges Justice A.K. Desai started throwing the cases. My heart was sinking. So my turn came. I began well and showed 2-3 judgments. But he would just simply look at it and say, no, there's nothing in this. So it happened about 2-3 cases and then he was about to dismiss the case. At that stage, I remember one elderly Maharashtrian lawyer was sitting by my side. He started telling me in Marathi, don't give up, push. So I told the judge, I want to read 3 more judgments. So he allowed me to read the judgments and finally said, okay, rule. The petition was admitted. I literally collapsed in the chair. And the fun of it, he refused to stay. So it was kind of a Pyrrhic victory because anyway my client he could not get any relief.
The greatest memory of feeling as a junior lawyer is when you face what you feel is a hostile judge and you manage to turn him, at least get him to agree with you on.
Of course. So, and I don't know whether you must have appeared before Justice S.K. Desai.
I've appeared before him in arbitration. But he was razor sharp, as you said.
Very sharp judge. I still remember him.
Were there any other judges or lawyers who inspired you during your career as a lawyer?
When I went to Bombay High Court, I joined Mr. Bhimrao Nayak. He was my father's junior in Solapur. He had a thriving practice. And then later, we appeared against each other in several cases. Virtually, there would be half a dozen cases where would be opposing each other.
On a daily basis.
On a daily basis. And then, but still, I respect him as a lawyer. According to me, he was a lawyer's lawyer, having great court craft and a personality, tall, handsome, and a booming voice. So I would rate him as one of the leading lawyers on the appellate side. Secondly, I recall engaging Mr. Ashok Desai in an election petition, which was a trial. And Ashok Desai had a thriving practice on the original side. So he conducted the cross-examination of the returning officer. The way he conducted that cross is simply, I would never forget that. And then I would meet him in his chamber. He was such humble person. Very humble, very nice. And he was a fascinating orator and having a great court craft. So I always remember and admire Ashok Desai, and I also knew his wife, Swarna Ben. She recently passed away. Then you asked me about judges. Again, it's very difficult to answer this question because there were many judges who impressed me, who inspired me. Looking back, I would say that Justice Chandorkar was the complete judge. His grasp, his understanding of law, his flair for writing, his command over both civil and criminal law. Unfortunately, he was not taken to Supreme Court. He retired as a Chief Justice of the Madras High Court. Then I believe the other judges who impressed me or who inspired me, I would say, one is Justice P.B. Sawant, a very humanist judge and has an empathy for poor, marginalized, the working class, the backward classes. Justice Suresh was like him. Justice Suresh was there for a short while. Both Justice Suresh and Justice Sawant were inspired by Justice Krishna Iyer. Then I must mention Justice Sujata Manohar. She was the first female judge, and there was a funny dilemma whether to address her as lordship or ladyship. So difficult to change your habits, and she was very soft-spoken, very dignified, but at the same time very firm. And one last judge I want to mention, who according to me was the most scholarly judge in Bombay High Court. That is Justice Madan. He was witty. His appearance was a little unusual, a little eccentric, but behind that facade, he had a brilliant mind and very scholarly. And one should read his judgment in State versus Kusum. Or Kusum versus State, I think, on the latest patent, or his judgment in Tulsiram Patel's case in the Supreme Court.
There are a number of stories of how Justice Madan enjoyed himself on the bench.
Oh, yes. And the cost of lawyers. So I must tell you one story of Justice Madan. And this was on the appellate side. He hardly sat on the appellate side. So he was sitting with a junior judge. I do not wish to mention his name. And the one junior was trying to tell the bench something which he was not clear. And after some time, the junior judge, the other judge, he got exasperated. And he said that the you have vested time of two eminent judges of the Bombay High Court. So Justice Madan said, no, only one. So this is how, it's a great sense of humor.
Absolutely. You had a thriving practice as a lawyer. What inspired you to make the transition from the bar to the bench?
It's not easy. I must say that I always wanted to be a judge. But judgeship is very different from advocacy. It's difficult to change the rules overnight because the traits or qualities or requisites of a judge are different from the lawyer. So it takes time. I will tell you a very interesting experience I want to share with you. As a judge, my initial days, I think it was my second sitting, and I was sitting with a senior judge on the criminal side. A petition came before us. There was a Muslim girl when she was born in India. When she was 3 or 4 years old, her mother took her to Pakistan. In 50s, she came back to India and lived in India for almost 4 decades. She married. She got a daughter of 17 or 18-year-old. So one day she was simply arrested and deported, put in the train and deported. So her daughter and husband rushed to the court. I didn't know much about the citizenship law. And somehow I could see the enormous injustice in this case. And somehow the matter got adjourned. In the night, I studied like a lawyer, I studied the citizenship law, and I could get a very important point. If one is born in India, then he becomes a natural citizen. And if he has acquired foreign passport later, by acquiring such passport, whether he or she has relinquished the citizenship has to be decided by the central government, and for that hearing was a must. Natural justice ought to be followed, and that was not done. So next day I showed all the judgments to my senior judge. We called the lawyers next day and asked them to bring that lady back. Unfortunately, by that time the train crossed Indian border. And I don't know what happened thereafter. It was very frustrating.
Very unfortunate.
Very, very unfortunate. And then I realized that there is so much of injustice in the society, particularly in our Indian society. There are like the discriminations, biases, oppression, poverty, all these are. So a judge needs compassion, some kind of empathy apart from the knowledge of law. So that's always helpful. And in those days, Gaurav, you know that there would be hundreds of petitions for admission on daily basis. So I would read practically every petition thoroughly at every matter or petition or appeal, and just not to throw the case, but to understand the case fully, and if possible, to help the parties.
In fact, I remember one incident where I appeared before you. It was a family dispute. Mother had died. There were 5 brothers. One of them who took care of the mother was demanding a double share, saying that there's an oral will. And I remember you calling the client to court, or that party to court, and saying, what is all this? Please settle it. And surprisingly, or not surprisingly, in fact, because of your word, the next day the matter was settled and they were sharing a bungalow. And I think probably they lived happily ever after, if I can use that terminology.
I don't remember the case, but
No, of course, it was. You've done it in so many cases, but I distinctly remember it because I was very fresh, a junior in the profession, and to have a judge solve a case in one hearing was something which was really
as a judge.
Left a lasting impression on me. You've been a judge of the Bombay High Court. You were the Chief Justice of the Madras and Delhi High Courts. Did you notice any differences in the way practice was carried out in those courts, or how lawyers reacted to certain situations in those courts?
I went to Madras High Court in 2005. Madras High Court is a chartered high court like Bombay and Calcutta. So it's a beautiful building. There are many buildings, but facade is different. So they have like original side. I mean, they have Bombay Bar and then Western India. So they have also two associations. One is a Senior Bar Association. The other is Advocates Association. The bar is not as cosmopolitan as Bombay, but the very cultured bar. I would say that the cultured people, because art and music is part of their life. So the by and large, the Madras High Court, you would find there, particularly on the senior bar, they were as professional as the lawyers in Bombay High Court. Unfortunately, this Dravidian politics has affected the bar to some extent. And I want to share with you this very interesting episode. So, we passed some orders against the DMK government. And then Chief Minister Karunanidhi, the sitting Chief Minister, he made some comments against our bench and also against some other judges. So there was a furor, and a contempt petition was brought. My view is that the contempt power should not be lightly used because somebody has criticized that. I felt that the contempt power should be used only when the rendering justice becomes impossible.
It affects the administration of justice.
So they gave some wishy-washy apology. That's a different issue. So when all this was going on, one day I walked in the court and I found there were flowers everywhere. Flowers in the corridor, flowers on the ground, flowers in the courtroom, flowers everywhere. So then I was told that AIDMK, because this was a DMK government, so AIDMK people came, or lawyers came with truckloads of flowers. And this is what they wanted to show how they respect the judges. Delhi High Court, of course, is a newer High Court. It was established in 1970s. But it is very professional. It has unparalleled infrastructure, I would say, and particularly about judges, I mean, which I found very interesting. On any given day, in the parking section for the judges, you will find at least 10 or 12 cars till 8 or 9 o'clock in the evening. So they were not sitting late but they would be working in the chambers late. I could do something in Delhi Bar, which is Delhi High Court. Firstly, I started the first arbitration center attached to the High Court. Then the other issue was about the family courts. There were no family courts in Delhi. Family Court Act had been passed in 1996. I reached Delhi in 2008 and there were no family courts. There is some provision in the Family Courts Act which restricts the appearance of the lawyers. So lawyers were opposing it. I could get a judgment of Bombay High Court which read the provision to mean that the appearance of a lawyer is a matter of right and denial is an exception. So with the help of that judgment, I could persuade the bar, and we had this family court to withdraw the opposition, and the family. And the other is, lastly, I should mention about the disclosure of assets by the judges. I had issued that right to information judgment. I said that even Chief Justice of India is covered by the Right to Information Act. So I persuaded my fellow judges to declare their assets on the High Court website. And this was just 2 days before my retirement.
So you delivered many landmark judgments.
Right, well, we're cutting in with that big breaking story at this hour. A huge victory for India's gay rights movement. In a landmark judgment, the Delhi High Court today has declared that consensual sex among gay adults is legal and therefore not punishable under Section 377 of the Indian Penal Code. The verdict, in effect, decriminalizes homosexuality in India and comes on a petition filed by the Naz Foundation and an activist group called Voiceless against 377.
Naz Foundation Judgement was a significant milestone in Indian jurisprudence. What was the thought process which went in delivering this judgment?
See, I will tell you something, the kind of a background. See, in late 1990s, a delegation of German legislators came to Mumbai. I was invited. One of the legislators mentioned about Section 377 and said that the government is not going to repeal this law, this particular provision. So, but the judges can do something. And he cited a decision of a German judge. So I told him that these judges may not be able to do it. It's virtually not possible. And it's so strange that this case landed before me 10 years later in Delhi High Court. The first thing which is very peculiar about this case, government was represented by two departments, Health Ministry and the Home Ministry. Health Ministry supported the petitioner and said that the provision should be repealed. The Home Ministry said that these are all Western ideas. They have no place in Indian culture. The majority disapproves the homosexuality. So this is against public morality. So the issue of right to health was on the forefront. When Naz argued the right to health as a challenge to the Section 377. But what we thought that the argument was that this 377 creates obstacles in treating HIV/AIDS affected persons. So we thought that suppose there is a cure to HIV/AIDS in the future, you cannot base the constitutional challenge on right to health alone. So we looked beyond. We said that the word sex in Article 15 should be read to include sexual orientation. We read the Article 14 in a completely different way vis-a-vis LGBTQ persons. But the most important, according to me, is the enunciation of idea of constitutional morality, relying upon the Dr. Ambedkar's statement in Constituent Assembly.
It would be the act of greatest statesmanship for the majority party even to make a concession to the prejudices of people who are not prepared to march together. And it is for that I propose to make this appeal. Let us leave aside slogans. Let us leave aside words which frighten people. Let us even make concession to the prejudices of our opponents. Bring them in so that they may willingly join with us on marching upon that road, which, as I said, if we walk long enough, must necessarily lead us to unity.
So the idea was this, that any moral legislation must be tested on the touchstone of constitutional morality and not the morality of the majority. For example, the majority approves untouchability. That's majority's morality. But that's not constitutional morality. Constitution prohibits untouchability. So this is how we put it, and now the Supreme Court has expanded it, applied it, used it in several cases.
It was indeed a path-breaking judgment and
yes,
finally upheld by Supreme Court.
So I believe that India changed thereafter, the whole attitude about the
even the international view of India has changed on these issues, at least. I mean, how do you deal with the subsequent reactions to this judgment?
Okay. So when we pronounced the judgment, I read the last portion of the judgment, and some people there, they cried, they started weeping, they wept with joy, I would say. And then I came home, I was very exhausted. My wife had gone to Mumbai, and I was not sure about the reaction of the general reaction to our judgment. I thought that there might be a backlash. But and then my wife called me late in the evening and asked me whether I'm watching TV. And they said, your judgment is everywhere.
Well, it's been a day of high emotion for the gay people across the country, many of whom have been harassed and bullied by authorities who use Section 377. There are many, many people who have lived in the shadow of fear for 20 years or more, who say that it's only now that they feel genuinely free.
Today we're here outside the Delhi High Court where just a few hours ago a landmark judgment was issued decriminalizing homosexuality.
Delhi High Court today has delivered a historic judgment decriminalizing homosexuality. In a landmark verdict, the High Court passed an order reading down Section 377 of the Indian Penal Code, making homosexuality between consenting adults legal.
But that moment stuck in my mind. When we actually read the judgment and the reaction in the court, how those people, there were many in number, the LGBTQ community, and how they reacted to the judgment.
After you retired, apart from the usual avenue of arbitration, you took up various other activities. Can you tell us a bit about the activities which you were involved in and are involved in today, apart from arbitrations?
So after my retirement, Miss Medha Patkar approached me regarding the issues of persons affected by Narmada Project. There were thousands of people affected by this project, mainly in MP and Maharashtra. And with her, I visited several villages. I met hundreds of affected people. So this was the first time I was coming out of this ivory tower and meeting people in flesh and blood. Then you see, the People's Tribunal is one way of bringing the people's issue in the public domain,
yes.
On the forefront.
So apart from the People's Tribunal, you've been involved in the Law Commission. Can you tell us something about your involvement with the Law Commission?
I got a tenure of about 19 months out of 3 years in that law, because someone else was the chairperson. He resigned and I was appointed in his place. In these 19 months, we issued 21 reports on varied subjects. So out of these 21 reports, some reports are fully accepted by the government, like the Arbitration Act, Amendment to Arbitration Act, which came in 2015. Then the Commercial Courts Act, which was this was on a suo motu basis we presented, and it was accepted in full. I also made a report on death penalty. I am an abolitionist. I always supported abolition of death penalty. I am not happy with my own report because for some reasons we recommended that death penalty should be abolished in phase-wise manner. So that was really not adequate. But one report I must tell you, which according to me was very important. You must have heard about Baba Amte and his work about the leprosy affected persons. So I visited his ashram when I was in Bombay High Court. And I was really moved by their plight, the discrimination against them. And the leprosy is curable. With some medication, a leprosy patient can be cured easily, maybe 6 months or 1 year's medication. So I decided to take up this issue and I made a report and I said for reforms in law, because in many laws discriminate against leprosy affected persons. Unfortunately, the government did not act upon that particular report, but the Vidhi Center has taken it up in the Supreme Court, and currently Supreme Court is dealing with that report.
You were also involved in the Delhi Riots report. Would you like to say anything about that? Yes,
that is one report which I must mention, that this which we delivered recently. It was a fact-finding commission on the Delhi riots. Now, one aspect I must bring to your notice, that there is a section containing how the certain media houses incited the riots. So we examined hundreds of hours of footage of those channels, and we made this report.
One of the important issues which is facing the society today, how media can be used or misused to incite violence or incite
that is
strong opinions.
I find actually, in fact, the Supreme Court intervened and issued directions against certain media houses not to use that hate speech,
Absolutely.
Which had become very common, particularly in electronic media.
Yes. What are your views on the judicial appointments in India and the collegium system?
I would just tell you at the outset about the two classic critic on the judge's case, second judge's case and third judge's case. this critique is by Lord Cook of Thorndon, a New Zealand judge. So his titles are very telling. For the second judge's case, his paper is titled as Where Angels Weep. And for the third judge's case, the title is Where Angels Fear to Tread. The fools rush in. This is what he wanted to suggest. So we had a consultative process which was visualized by the Constitution. So the executive makes the appointment through the President, but in consultation with the Chief Justice of India and certain other important functionaries. Then in Nehru's time, it was all went very well. So Chief Justice had a kind of a veto. In Indira Gandhi's time, as you know, it all imploded. She wanted committed judges. Even in Rajiv Gandhi's time, there was allegations of court packing. Then came the first judge's case. Unfortunately, in that case, the Supreme Court said that the Chief Justice's advice is not binding on the government. And that was a complete disaster. It means that the whole process of appointment would go in the hands with the government. And then came the second judge's case and third judge's case. And there they said the consultation means concurrence. So these are two different words. In fact, in the Constituent Assembly debate, an amendment was suggested that it could be done only with the concurrence of Chief Justice. This was rejected. But still the court held that, and they had created this collegium. So collegium, initially there was no problem. So this is judges appointing judges. So there were coalition governments. Now there is very strong executive since 2014. So first they introduced this NJC Act. So let's have appointment commission. I think that was a great idea because there are appointment commissions in many countries. This collegium is completely opaque, and for example, Justice Rumapal described this as the most well-guarded secret in the judiciary. So therefore they said that they made a constitutional amendment for providing national commission. So that was struck down by the Supreme Court, and now the position is this: it's a very strong government. They either don't act upon the nominations, they keep the files pending for years, or for example, there is a Kashmir judge whose appointment came after 5 years. There is another judge, Sobhashekhar Sundaran is a judge of Bombay High Court. Yes. His appointment could come only after 11 months with the intervention of the Supreme Court. Then there is a question of non-consideration, not sending the certain names. For example, it seems that Justice Akil Qureshi had passed certain orders. I guess perhaps that's a perception. So his name was not sent, and it is reported that Justice Rohington Nariman insisted that he's the senior most judge, and his name should be sent. And unless his name is sent to the government, he will not agree on any names. As a result, for almost 2 years, there were no appointments. Then for example, recently, you will find letters by Mr. Fali Nariman, Justice Madan Lokur and many others about Justice S. Muralidhar, one of the finest judges in the country, but his name was not. So this system has not really worked well. And now because of this stalemate between the government and the collegium, there are hundreds of vacancies.
What is your opinion on the role of public interest litigation in India, particularly to ensure social justice?
I would say that the public interest litigation, that is PIL jurisdiction, is the greatest contribution by Indian courts to the world jurisprudence. You'll be surprised to know that in some countries, newer constitution like South Africa, Kenya, right to file a PIL is recognized as a constitutional, as a fundamental right. So this is a fundamental right of a citizen to approach the court by way of a PIL. And PIL has done wonders. There is no doubt about it, that at least in the initial days, because you remove this locus standi requirement, and this has given voice to so the marginalized, to the oppressed communities. It has worked, done some wonders in environment, in child rights, women's rights, prison reforms. It has really worked. But I believe judges should understand that there are limitations in any PIL. You cannot reform the society. You can do your bit in a PIL. It can be a catalyst for bringing some change, but it's not easy. I would say that the cases like Brown versus Board of Education in America, where the segregation was a court abolished the segregation, or say Vishaka case, or even Naz, such cases come once in a while.
There's also cases of PILs being misused by corporates or by vested interests. And how do you prevent that?
No, there is a misuse. There is no doubt about it. There is a misuse and there are many frivolous petitions. But one thing I must clarify. PIL has not increased the burden on the courts. That there are very few PILs and they are all dealt with by the Chief Justice's bench. So it's not that because of PILs the court's burden is increased. No, not this way. But certainly there are frivolous PILs and which ought to be dismissed, and you will find it actually some courts dismiss those PILs.
Given that you were instrumental in laying down the law in various aspects of the law, particularly regarding free speech, what is your opinion on the state of free speech in India today?
I would say that the free speech is under tremendous stress nowadays because of not only this tendency to treat any criticism of government as anti-national and the use of these draconian laws like UAPA or PM or NIA. This is frequently used against the journalists, against the civil liberty activists or against the critics of the government. And the media, I find the mainstream media is almost compromised. There are hardly, according to me, very few media houses which maintain an independent view. I'm not saying that they should all the time criticize the government, but there has to be an independent version.
Balance also.
Some kind of a balance. So it's very difficult to watch that this media persons, those all anchors, they all one after other supporting the government policy. So there has to be some independent and critical role which is expected from media, which is unfortunately is not happening in this country.
Do you think the judiciary can play a more proactive role in protecting fundamental rights, the right to speech and civil liberties of people in India?
See, when civil liberties are challenged or the free speech is challenged, the only remedy for the citizen is to approach the court. And I find that in many states, the rule of law is collapsing. For example, take this bulldozer justice. The houses are being demolished only on the suspicion that the person, and one of the persons is residing there, is involved in some crime. Lakhs of people lost their shelter because of this bulldozer policy. Then there are fake encounters. In state of UP, in the statistical data shows that in last few years, there were more than 1,000 fake encounters by police. Now, the judges should take a position against this. For example, none of the high courts took any position about this bulldozer justice. It's now only the Supreme Court which is now inquiring into this issue. For example, in fake encounter or encounters, I would say, many of them are fake. The courts have not intervened. Fortunately, in Badlapur encounter, recently the division bench has taken up the case, and there was a report made by Justice Shirkurkar and Justice Baldota's committee on the Hyderabad. You remember that immediately after the accused were arrested in that unfortunate rape and murder case, they were all actually shot dead. So these are the cases where the High Court can play a very important role. I mean, Supreme Court is reminding the High Court that the bail is the right, is a rule, and denial is the exception. But I find that during emergency, the High Courts stood by and large by the people of India, and the Supreme Court let the people down in ADM Jabalpur case. My perception is it is exactly the reverse position. By and large, barring some very honorable exceptions, by and large it's difficult to get a relief in cases involving civil liberties, free speech, etc. One has to go to the Supreme Court. That's a troubling point, and it should really happen. It should be done at the High Court level.
Probably the High Court's also so overburdened with cases that
may be so, but
sometimes may not even have time to.
I can't accept this excuse. I mean, surely High Court can do. Really deal with these situations.
What do you believe are the most pressing challenges facing the Indian judiciary in the next 1 or 2 decades?
I mean, the other is the outdated procedural laws. The criminal justice, for example, is literally collapsing. Now they brought some new laws, but this is mostly old wine in new bottle, what they say. More incarceration, stricter punishments. There are some good aspects, but that was an opportunity to revamp the criminal justice system.
And particularly the procedure.
The procedures. We are still continuing with all these colonial procedures. There has to be a holistic look at the procedures. And the whole adjudicatory process must be re-examined. How it should work in a country like India with such vast amount of cases.
More in the lighter vein, I know that in school, the library was a safe haven for you. And you loved reading books, as you have told us. What are the books which you're currently reading?
I am unabashed fan of Mr. Salman Rushdie. So he was recently, you remember that there was an attempt on his life and he lost his eye, and he has written a book called Knife. He was attacked with a knife. It's a very interesting book which I read recently. Then, of course, my favorite writer is Haruki Murakami. So I read almost all his books, but the one story collection I missed, and the title is very interesting. Its title is Men Without Women. So that's an interesting short story. I'm also reading a Tokyo Judgment. It's about the Tokyo trials. It's a very big book, Larry Bass, and it runs into some 1,000 pages. I don't know whether I'm going to complete it. Cinema is another avenue which I read and watch some interesting movies So this Lapata Ladies, I like the movie, and I think the Chief Justice of India arranged a special screening for this movie. But that's a quite pleasing movie. Very thought-provoking at the same time, very well made.
Thank you so much for being on the show and letting all know about your experiences in life, particularly with relationship to the judiciary, both as a practicing advocate and as well as a judge.
I really enjoyed this session talking to you, Gaurav. It's a great pleasure. Thank you.